Good evening. Welcome to another Be Informed session. My name is Carl Buhariwala and I founded Be Informed to help people make good decisions. Today we're joined by Athan of Maeve and Brian Associates. We'll be sharing some information about parenting matters, in particular parenting responsibilities after separation. Before we proceed, I would like to acknowledge the traditional owners of the lands on which we're meeting today and pay my respects to their elders, past and present. Today's session is being presented from Australia, so the matters that are being considered is in relation to Australian law. So if you are considering this seminar from a jurisdiction outside of Australia, you may wish to reconsider the applicability. And also the information presented to you today by Arthur is current as of this month. So if you do rely on this information in the future, you may want to check in to see if it's still current. But otherwise, all the information is factual and based off objective information, so hopefully it'll be useful to you in your circumstances. Arthur has kindly prepared a one-page handout, so all the information in this presented to you in this seminar will be summarised in the one-page handout, which I'll be emailing through to those that are registered by email to Eventbrite. And following the seminar, which will take roughly 25 minutes, there'll be time for Q&A. So if you do have any questions, please feel free to share them with me directly in the Q&A chat function, and I will relay them through to Arthur. And we've got a few questions that we received ahead of time by email, so we'll start off with those in the Q&A session and then proceed to the live questions. So with that all in mind, this session is being recorded, so it'll be made available to you after today on our YouTube channel. And that's probably about it from a formalities perspective. Arthur, I'll hand over to you.
Thanks, Carl. Much appreciated. It's always a pleasure to be here to present for Be Informed. Ever since Be Informed started up, I've been in touch with Carl, and Carl's very kindly invited me. I think it's for the third time. So yeah, it's always a privilege to be here doing this and providing information. I share the same core purpose as Be Informed, and that is to provide information to the community to help people be better informed when they make decisions for themselves. And I have to say that it's so crucial, so crucial when separation does occur, or when someone is contemplating separation, that the information should be properly considered with regard to a legal position, with regard to options, with regard to life circumstances, and hopefully today this seminar can be a little stepping stone, a little help in that journey for you, if that is you. I should just say at the outset, the title of this seminar I've chosen is Parenting After Separation, or Parenting Responsibilities After Separation, as Carl's got on that first slide. This seminar is not designed to be in place of legal advice. As I've already said, this is information only, and if you would like to seek legal advice, you can very much do that. You have the right to seek legal advice, and that is most appropriately done with consultation with a lawyer, where a lawyer can review your circumstances, take instructions from you, and provide advice, apply the law directly to your unique situation. No family law situation, no family is exactly the same. There are always unique differences to every situation. So I just wanted to say that at the outset before I jump right in. So parenting after separation is a broad topic, but it's one that we must consider with care. It's obviously, in the event of separation, so upon relationship breakdown, there are so many questions that arise when it comes to parenting, and it can often result in sometimes an easy situation, but more oftentimes it results in a roller coaster ride. I've heard it described in that way many times, where there's highs and there's lows, and the lows can be pretty low. So so it's, as I've said before, it's really good to consider what the Family Law Act in Australia has to say about these things. So the Family Law Act is a federal act. It applies to all states and territories in Australia. And as Carl has already mentioned, if it's a jurisdiction outside of Australia, it does not apply, and you would probably be best seeking information elsewhere. The first slide, Carl, if you don't mind clicking to that, is called the best interests of the child. So after separation occurs, one of probably the most important question to ask when considering parenting after separation is, on what basis do we make parenting decisions? Why? What is the reason? What is the reason for making a certain parenting decision? Now, in Australian family law, the answer is we make decisions with regard to the best interests of the child. Now, this phrase is in Section 60cc of the Family Law Act 1975, and it's the guide for how parents ought to make decisions for children. I should say just at the outset as well that there have been, as recently in the last couple of weeks, there have been significant changes made to this area of law, just recently passed through Parliament. So I will be touching on those briefly in the next slide. However, I'm just flagging that from the outset here. So just reading off my slide, all parenting arrangements must be focused on the best interests of the child. In working out what is in the best interests of the child, the law states that parents must consider a range of matters, including the importance of a child having an ongoing and meaningful relationship with both parents, family violence or safety concerns affecting the child's care, the relationship between each parent and the child, the extent to which each parent has sought to make decisions about, spend time with, or communicate with the child, financial support provided by each parent, and views expressed by the child. These factors, and I'll go through many factors throughout this seminar. Some of these may be applicable to you, some of these might not. However, these are, in my experience, these are very common things, very common questions to be asked by parents when facing parenting decisions after separation. And these factors are important things to consider when considering such decisions to be made. Carl, if you don't mind moving to the second slide. Carl, if you don't mind just moving to the second slide. So the second slide, I'll just go off my notes, says, what are some parenting issues that parents may face after separation? Now, there are many issues to be considered and worked through by parents, including parental responsibility for decisions relating to children, care arrangements, communication, schooling, medical issues, and much more. Now, I would just like to make a very crucial distinction. There are two important concepts that parents need to understand, and that is the difference between parental responsibility and care arrangements. In Australian family law, we have the concept of parental responsibility. What this means is the responsibility that parents have, or the responsibility that parents have to make decisions on a range of matters for children. Now, parents in current family law, so I mentioned recent amendments just before, in current family law, there is a presumption that parents have equal shared parental responsibility. What that means is that both parents after separation have the same, the equal responsibility when it comes to making decisions for their children. Now, this is different from discussing care arrangements for children. So when I speak about care arrangements, we talk about the amount of time, overnights, day communication time, the amount of time that children spend with each parent. These two concepts are totally separate, sometimes interlinked, but they should be considered separately. And the Family Law Act makes that very clear. And in fact, one of the amendments brought in very recently in the recent Family Law Amendment Act was to make sure that there's no confusion about these two concepts. So having equal shared parental responsibility does not translate to equal shared care arrangements. Okay, so equal shared parental responsibility does not mean that it is best for children to spend equal time. So however that might look like, for example, week about arrangements, etc. It's very much an assessment of individual circumstances and what has been happening as status quo arrangements for a long period of time, an assessment of who the primary caregiver is, and a whole myriad of other matters as well, depending on your family situation. Now, just while I'm at it, given that I've just explained those two important concepts, I'd just like to quickly canvass the major parts of the amendments that have been passed in the recent weeks. So I've discussed the issue about parental responsibility. In terms of best interests of the child from the previous slide, that concept is very much enshrined in family law and will stay enshrined. However, in the current Family Law Act, there are the way that the best interests of the child is set out there are two primary considerations and a number of additional considerations when it comes to considering what is in the best interests of children. So the two primary considerations currently are, firstly, the presumption for children to have a meaningful relationship with both parents after separation, and the second primary consideration being the paramount consideration of the children's safety and their welfare. So those two factors have often been weighed up together. The importance of children having a relationship with both parents and weighing that up against the safety of children in one or both parents' care. Moving to the recent amendments, these two primary considerations have actually been repealed and have been just included as a bunch of all equally weighted considerations when considering best interests of the children. There's many reasons for why Parliament has drafted this and why it's now law. And in terms of law, I believe that this law is coming into operation, I believe, mid or early next year. However, in terms of these two considerations becoming one of many, it gives courts and it gives parents the opportunity to weigh up many factors. There's a great discretion when it comes to applying all of these factors to the individual circumstances of families. So, in my view, that's a positive. That's a really good step forward, and it's helpful to assess all of these factors in a holistic way. One of the major changes, the third major change in amongst these amendments is a consideration of there's a case called Rice and Aspland. It's a very well-known family law precedent that has been around for many years that talks about the ability for parents to be able to vary or set aside final parenting orders on the basis that there are significant change in circumstances. This family law amendment bill codifies this principle. So this is now essentially been made into law, which is a very good thing. And I'll explain a little bit more about court processes and this notion of final court orders, final parenting orders, and setting them aside. I'll explain a bit about that later. So just revisiting where we're at on this slide, there are many parenting issues that parents may face after separation. These issues will not be the same for each family. There are certain hot topics with one family. It might look very different for another family, but these are some of the issues that parents need to sort through separation and need to either reach agreements about or have decisions being made for them about. I've written my second dot point on that slide is a recommendation by myself, and I've seen many, many court orders made on this basis, and it's often recommended by psychologists who work with separating parents. I'll just read it. If you are recently separated with children, please consider completing a parenting after separation course. These courses are offered by many organisations, including, I've just written 3 there, Relationships Australia, Relationship Matters, and Better Places Australia. These are free courses designed to equip parents with having an awareness and the emotional and tools, I guess, in terms of navigating the tough times and tough parenting decisions and explaining matters to children. All of these matters are considered in these courses. So I highly, highly recommend that. And it's very much recommended by psychologists and by the court, having seen so many orders for such courses. I should also say that there are other courses that might be very, very useful for you and that you may wish to investigate. These might include anger management courses, men's behavioural change programs. There's parenting orders programs. There's a whole range of free and paid programs which may assist with parenting after separation. Another really good one is called Tuning Into Kids, if you want to take note of that. Thanks, Carl. I'll just move on to the next slide, if that's okay. So we've talked about issues. We've talked about the basis for how the Family Law Act, for how family law in Australia requires parents to make decisions, and we know that that basis is the best interest of the children. Now, how do we navigate these issues? I mentioned before that probably the best way of resolving issues is by agreement. Okay, it doesn't matter what issue you've got, doesn't matter what area of law. Coming to agreements is the best way, it's most time efficient, most of the time, most cost-effective way of moving through issues. So I've just put there in first stop point, reaching agreements when parenting after separation is ideal. Agreements can be informal or written down in the form of parenting plans or parenting agreements. So when I say agreements can be informal, it can be simply you and your ex-partner reaching agreements together verbally or written down between yourselves at a dinner table, or if you're very much amicable between both of you, it might be by text message, you might be picking up the phone and just reaching agreements. It might be for a long period of time, it might be ad hoc agreements, it might be an agreement for what's happening tonight or even tomorrow. It could be literally on a short-term basis or long-term basis. It's totally up to you and it's within your discretion. Alternatively, if both of you need more structure, and in my experience, more structure is generally a good thing, especially when there's a bit more conflict, and that's not necessarily uncommon through many family law situations. That's when parenting plans or parenting agreements can become very, very useful. Those can be drafted by you, can be drafted by lawyers, can be drafted by mediators, depending on the situation. Third dot point, parents can negotiate and reach parenting agreements between themselves. That's what I've just said. And parents should, I encourage parents to do that for themselves. That should be the primary way that these issues get resolved. If issues can be resolved between parents when it comes to parenting without the need for external intervention, that is fantastic, and that's a great way to move forward for the sake of your children. It means that children know that parents are making decisions between themselves for them without the need for anyone else, and that's helpful and a good thing for children. The fourth dot point there says sometimes reaching agreements can be difficult, and I see a lot of these types of situations. Obviously, lawyers are often required to intervene when there are difficulties in reaching agreements. However, there are many processes that can help you reach agreements. Some of these include free mediation services. So organisations such as Relationships Australia and Better Places Australia, they offer free mediation services. They call that family dispute resolution, and that is a great resource for many parents who need the input of a mediator, or another word for input might be the mediation aspect of someone who's sitting in between an intermediary of sorts. I've also got there a private or paid mediation. This is where the parties choose to pay mediators. Oftentimes, this is a step that is taken with the assistance of legal advice. Often my clients with parenting issues have asked me for an option for mediation, and sometimes we engage a mediator, and this is where lawyers and the parties and a mediator can come together. Sometimes they can be in the same room. Most oftentimes, in my experience, these types of mediations are done by shuttle, so only the legal professionals, the representatives and the mediator would get together in the same room and then obviously break out to get instructions between parties. And that has been a very good way of helping parties reach agreements with regard to parenting or financial for that matter. And finally there, I've got their lawyer-to-lawyer negotiation. That's where you've got lawyers involved. You have lawyers ringing, calling each other, writing to each other in order to help resolve disagreements between parents. I should say that the end result of all of these processes, as this slide indicates, is to help parents reach agreements. Now, once you have an agreement, whether it's a parenting plan, parenting agreement, informal agreement, an agreement is not binding. Okay, so any of these agreements that I've talked about on this page, they're not binding on parents. These agreements are essentially a record of the intention between parents who have reached that agreement. If parents want to go to the next step of having that agreement being made formal and binding upon them, there is an avenue for that. And the avenue for that is an application for consent orders. So what that means is that parents, after having reached an agreement, can apply to the court, usually with the help of a legal representative, but sometimes not necessarily. It means an application to the court to ask the court to consider the terms of a proposed parenting plan, parenting agreement, and asking the court to make final parenting orders in those terms. Now, the court obviously has a duty to apply family law to any situation. And when receiving such an application, the court would essentially assess such an application, such terms of agreement, to consider whether the terms of agreement are indeed in the best interests of the children. And the court obviously has a final say as to whether it will make final parenting orders in the terms that are agreed between parties. So that would be the best step if parties have reached an agreement and want to make it formal and binding. Final parenting orders by consent via an application for consent orders is the best way to go. Once you have a final parenting order, it doesn't matter whether it's by consent or by determination of a court, a final order is binding and enforceable, and parents should assume that's always the case. It's very rare for final orders to be set aside or varied. That can only happen in very limited situations. And I'll discuss that briefly as we move on to the next slide, which is about court. Thanks, Carl. So as discussed, aside from the situation of parents reaching agreements and having those agreements being made formal by way of application for consent orders, first dot point, if parents cannot reach agreements about parenting arrangements, parents may make application to the Federal Circuit and Family Court of Australia to seek interim and final parenting orders. Okay, so when communication breaks down, when there's high conflict, when mediation is inappropriate, in some circumstances, mediation is not appropriate. And I can think of situations like family violence, there's serious child abuse, serious family violence, communication is impossible, there's high conflict. There's complex situations happening. There might even be urgent situations. This is where parents may, and sometimes on advice, they should make application to the Federal Circuit and Family Court of Australia to seek those final parenting orders. Now, the difference between interim and final parenting orders, sometimes I get that question. Interim orders are orders that are not temporary is one way to put it. Interim means it's for a time until a final order is made. So it's very, very rare. I would say almost impossible in the current framework of the court for a court to make final parenting orders at the first step of a court proceeding. The court needs to examine the application, make interim orders as to how to progress this matter forward, and eventually the court wants to give as many opportunities to parties to try resolving their matter before it is forced to list a trial in order for a judge to examine evidence and come to final decisions and make a judgment in terms of final parenting orders. The court does not want to do that. And I can tell you, I can say to all of you who are listening that it's statistics-wise, it's very, very rare for matters to proceed all the way to a final hearing. Most matters will settle, and what I mean by that is most parents who issue proceedings will actually come to agreements and reach final orders by consent some way through a court proceeding before a trial is listed. So that should give parents some confidence where a court proceeding is necessary, but it's very unpalatable in terms of the thought of proceeding all the way to a final trial where witnesses are required, where cross-examination is required, and it is quite a traumatic process on anyone's view. As I've said there before, in point 2, court orders are binding and enforceable. And the third point there, parenting orders are enforceable until children turn 18 years old, where they are legally considered adults. If you have more questions about court and the whole process, I encourage you to seek legal advice. Obviously, we're available here at Maeve, O'Brien & Associates. I'm a senior associate here. We'd be most happy to have a chat with you about your individual situation. Carl, if you don't mind just flicking to the final slide there, about safety concerns, intervention orders, and child protection. Sometimes parenting after separation can be very difficult, especially where there are safety concerns about the children. This may require an urgent intervention order to be made to protect the children or an urgent application to be made to the Family Court of Australia for urgent interim orders. Safety issues may require the intervention of child protection. When in doubt, please seek legal advice about your parenting situation. It is important to note when there are decisions to be made about children after separation, the primary, in terms of a course of action, parents should be very conscious that decisions should be made with consent of the other party. That's probably something to leave you with in terms of this seminar. Remember that parenting decisions should be by consent. If they are not by consent, there should be a very good reason why that it's impossible for an agreement to be made in that regard. And those good reasons include family violence. It includes the situations of child abuse, includes intervention orders, child protection involvement, etc. So I've just had a matter very recently where a mother came to me and there is an intervention order in place, and she's asked me whether she can take her child interstate for a holiday. And there are there's no parenting plan in place. There's no final orders in place. And for this mother, the primary consideration is to see if an agreement can be made with her ex-partner. Yes, there's an intervention order in place, even with the child as an affected family member. However, in the absence of any final orders about parental responsibility, it must be assumed, especially in this current environment where we have the current Family Law Act on foot, that both parents have equal parental responsibility until there's a final order otherwise. So this mother, I've advised her obviously to seek consent from her ex-partner, and if there's an issue there, that court proceedings may be necessary. So that's just a small window into one issue for one person. It might be very different for you, might be very different for the next person. When in doubt, please seek legal advice. With that, I think that'll just bring this seminar to a close. There's so much to say about parenting matters after separation. As I've reiterated throughout this seminar, please seek legal advice about your individual situation. And we're here at Maeve, O'Brien Associates, ready to assist if necessary. Thank you so much, Carl, for the opportunity.
Thanks, Arthur. As always, a very informative seminar on a topic that is, I think, quite pertinent, especially when things go wrong and separations occur. And then if you do have a child, well, what happens then, right, in terms of parenting responsibilities? So definitely something that always should be considered rather than overlooked. So Arthur's details are on screen. As he's noted, he's at Maeve, O'Brien and Associates, and they are specialists in this field. So if you do have any queries, feel free to reach out to him directly. As a reminder, this session is being recorded. So if you have joined late or during the seminar, you can watch the entire session online on our YouTube channel following the close of the session. So you won't have missed on anything. And Arthur has kindly prepared a one-page handout which will be shared after today's seminar. So the summary of all the key points made by Arthur will be contained in that document. So we'll now move on to a Q&A. And Arthur, I've got a few questions. And I think the first question sort of centers around consent. You talk about the consent, right? But what happens if a parent just doesn't want to have anything to do with it anymore? And you get a difficult sort of, scenario there. What can be done? You might have one that's wanting to do something and sort of discuss, and the other one just says, no, I don't want to have anything to do with this anymore, just go away. So what happens there?
That's a very good question. So in the situation where one parent does not want to have any involvement, I guess, with parenting decisions, it's in the absence of final orders, it's difficult it would be difficult for me to give advice for a parent to make a unilateral decision. I would be always encouraging parents to, in the absence of final orders, to have things in writing. So if there is a parent who is refusing to be involved, not wanting to be involved with any decisions, well, that's an agreement of sorts, in fact. So I'd be saying, putting that in writing and asking that question across text message, across email, would you like to have input in this decision? And if the answer is no, great. That's an agreement in itself. However, if there is pushback, no, I don't want to have input in that decision, but I don't want you to make decisions for the child by yourself. Well, then that's a problem. There's an issue there, and that issue probably needs to be resolved through with legal advice, probably through a mediation to try helping parents communicate better. But obviously, if that's not possible, through some sort of court order. However, yeah, it's a tough situation. I've dealt with many situations with clients where their ex-partner just wants no part, and it's very, very sad on the part of children. They don't want any part in their children's lives, and I've seen situations where the children really want that parent to be around for them, and I've seen partners, that my clients really want the father, for example, or the mother to be a better mother, to be a better father. Do your job, be involved with your children's lives. One of the main things that I say to my clients in those situations is that you can't ever change people, and I mean, that's true in relationships, that's true in friendships, and that's even more true after separation, where there's a situation where there's much less trust and much less care between separated couples. So yeah, unfortunately, if father or mother is not doing their job for their kids, it's really, really sad. But it's not within my client's control to change their ex-partner and make them a better parent. I hope that it's a vague question. I hope I've given answers with regard to several situations there, but hopefully that
you can sort of see it's
touches a
probably
few points.
definitely a common scenario. I would have thought, when especially after separation usually is the consequence of some form of communication or relationship breakdown between the adults. And if one person just doesn't want to talk about it, what can they do? And then an extension of that question is, and I think this is quite interesting, is can you appoint a delegate? Like, can you appoint a guardian? Can you appoint an auntie to be the one sort of taking those responsibilities moving forward? Or can the party that wishes to actually discuss or commit to the mother or father, whoever it might be, can they say, can we get that person's auntie or uncle or whoever to sort of be that other person or that support person? Can that work, or is that just because they're not a parent, they're not a they're not in scope, I guess?
When you say
like a guardian, could they appoint a guardian to be the one sort of making the decisions on behalf of the parent? Can they nominate someone?
That is a good question. Parental responsibility can I've seen situations where that has occurred, but that's in a like the situations I'm thinking about is where a parent is very much incapacitated. Okay, and in those circumstances, yes, a guardians can be appointed, and that's a completely different process. But if we're talking about the Federal Circuit and Family Court of Australia, interested family members can be involved, absolutely. And the Act specifically talks about grandparents having a very important, the right to apply when it comes to care arrangements and parenting arrangements. So look, it really depends on the circumstance. Yes, there are avenues where a parent is incapacitated or unable to make decisions, where yes, there can be a representative on their behalf. That being said, if a matter was in court, I would not be surprised if the court would say that no, there is no substitute for mum and dad, or it depends on who the parents are, but parents are parents, and there's no necessarily there's no substitute for that. I think a good example of that is when it comes to guardianship. Now, I do some wills and estates. If we talk about guardianship, and if, for example, I'm dealing with a client, a husband who, in the event of his passing, who would have sole guardianship of his children? Probably the mother. It wouldn't be, he wouldn't appoint someone else other than the mother, because it's probably in the kid's best interest to be with their mother, who is a surviving parent. So yeah, difficult situations probably needs individual advice.
Yeah. And when the court does make final orders and the parent or the both parents don't comply with those, like what's the next steps? Like, what can you do to enforce people to comply? Are there avenues for that, or
with final orders?
Yeah.
Okay. Yeah, good question. I didn't cover this in the presentation. Court orders are binding enforceable. I've said that. If court orders are breached, there can be quite severe penalties from the court. These can include financial penalties, can include, in the worst possible cases, can include imprisonment. However, in terms of enforcing court orders, it's generally incumbent upon the party who needs to enforce it to issue a contravention application to the court. Okay, so as part of that contravention application, you would be running it quite. It's almost like a civil matter in terms of pleadings. It actually becomes a very different type of family law matter, and you've got very specific breaches, and if found to be true, yes, the court has a whole range of power to in terms of penalties, and in terms of responding to those breaches, it may mean that the court adjusts final orders, and parenting arrangements can change. For example, if a parent is simply not abiding by court orders and the children are being compromised in any way, the court will make determinations about that. So again, very unique depending on the circumstances, but the court does have a lot of discretion when it comes to enforcing orders.
Yeah. And when parenting orders are made, right, because the arrangements outside of that are sort of non-binding, or when they are made, and it weighs in a particular favor, for example, one parent might have more responsibility than the other parent. Does that influence child support payments and sort of how that sort of works to sort of, if one parent has to do more and spend more time with the child or the children, can that influence those arrangements from a child support perspective?
Good question. Very good question. Now, in a previous session with Be Informed, I presented on child support, and that's key to your question, Carl, and it's a very good one. In this presentation, I explained the difference between parental responsibility and care arrangements. A lot of parents get these two concepts confused. It's very easy for them to be confused. Parental responsibility refers to the responsibility in decisions. Care arrangements refers to literally the percentage of care. Which nights are the children with me and which nights are the children with the other parent, okay? You can have equal shared parental responsibility, as in you must reach agreements on major life decisions for the children, and you, at the same time, you can have care arrangements that are definitely not equal, okay? So when it comes to child support, parental responsibility is irrelevant. It's care arrangements that count. What the child support agency, through Centrelink, what they care about is two things. One, the comparative, the care arrangements between the parents. So the percentage of time that the children spend with each parent. And the second thing they care about is the comparative incomes of the two parents. That's what child support is based off.
Interesting.
Yeah. So that's a good question though.
Yeah. Okay. So just reminding those that are watching or look, the difference between parental responsibility and care arrangements. And, okay, that was a good thing to sort of iron out.
Absolutely.
Good distinction. All right. And with the safety, the intervention orders, child protection slide that you talked about last, if there is a situation where one parent is pretty hostile or abusive or whatever it might be, there's domestic violence and the like, that would weigh heavily against that individual in terms of making decisions, right? For their child, would that sort of have an influence if it were to get to court and orders were to be sought?
Yes. The answer is yes.
Because one parent might be in fear of what decisions that person might make right down the line.
Right. And when it comes to family violence, and there's a whole range of things that may or may not have happened. Yes, family violence, child abuse, all of these safety matters are considered by the court when it comes to making orders about parental responsibility and care arrangements. For example, in serious cases of abuse and family violence, sometimes it's just not safe for a child to spend overnight time with a parent. It's just not safe. Okay. So in those circumstances, orders would be made probably for no overnight time. Okay. In other circumstances, it could be even worse. It could be that this person cannot be trusted with the children unless there is a third-party supervisor there all the time. Okay. So in those circumstances, there might be an order for supervised time, limited supervised time every week, every alternate week, whatever. Okay, those are serious situations, obviously. On the less, I guess, the less serious time, I don't want to minimize any crises and trauma of family violence. It's family violence is always not okay. However, there is a spectrum of the seriousness when it comes to these matters. On the lower impact spectrum, there are situations where there has been family violence between the parties. Okay, so and children have witnessed the family violence, which is family violence against them. However, the family violence might be verbal arguments, it might be anger, and that situation of family violence is not necessarily it's not necessarily existent post separation just by virtue of the fact of separation. So in those circumstances, you look at the risk, you look at the risks to the children, and in those circumstances, a court might consider that it's still appropriate for it's for unsupervised time, significant time with both parents. But again, heavily dependent on each circumstance. I'm just raising a whole lot of factors there, Carl.
Yeah. I think definitely those individuals in those circumstances will want to sort of really think through who's making the decision and
absolutely
who has that degree of responsibility when the ultimate objective, as you say, is the best interest of the child.
That's right.
And the final question that we've got, Arthur, is just around that concept, the best interest of the child. How do the children sort of voice their concerns in this? I know, children are not supposed to sort of really play a major role in this, right? Other than that objective being front of mind for the parents.
Yes.
Who has their say in mind? Like who can advocate on their behalf?
Great, and thank you for the question. That's really important. And again, due to constraints in time, I can't cover everything in a short 25-minute presentation. But in terms of the children's views, the court and the Family Law Act is very concerned about what children think. Now, what children think is not definitive of what is going to happen. Okay, what children want isn't always necessarily what's best for them. That's just by nature. Children don't necessarily know. They don't have the maturity to know what's actually best. So what's required is to have an assessment to understand what children want, and then weigh that up together with a whole lot of other parenting factors in order to reach an idea of what is actually best, what is in their best interests. Now, there's two major ways in which the court finds out about the children's views. The first way is through a family report. Okay, so I'll just use that term to include any type of child impact report through the court, any private family report, those type of things, where a psychologist is appointed by the court in some capacity to interview the parents and interview the children. So that's when a psychologist gets to meet with children, gets to ask them questions about their lives, about their opinions about different things, their dynamics, relationship with their parents, those sort of things. And at the end of that process, the psychologist who's trained in these areas would put together a very detailed report which can be relied as evidence to the court. Okay, and that report is usually quite persuasive when it comes to final orders in terms of what a court considers to be in the children's best interests. Now, obviously, parents sometimes disagree with these types of reports. Shadow reports can be ordered, but just to answer your question, Carl, that is one way through which children's views can be brought to a court. The second thing that I want to raise is the existence of the appointment of an independent children's lawyer. Okay, the job of the ICL is to advocate for the children's interests. Now, to date, the ICL's function is not to interview children, okay, currently, but simply to be there in the process to give the children's views a voice. So usually they're very much they're very much, in my experience, very much partial to a family report writer's opinions, and would be advocating for that in court. However, interestingly, in the Family Law Amendment Bill just passed a couple of weeks ago, one of the proposals, one of the new revisions to law, the ICO's role is being expanded to include to meet directly with children. Okay, so that's a very new thing, which we're yet to see how that's going to work out, but that's a new amendment that we've seen in the bill. So those are just two ways. And in terms of outside of court, there's processes called child inclusive mediation. That was on my slide and I didn't properly explain that, but it's a similar process where parents agree to go through a mediation, but engage a psychologist for them to meet with the children, so the psychologist can basically voice what the children want as an unbiased third party to add the children's view as part of the discussions in a mediation. So that's a very useful process to go through, and I've seen that being quite successful. But yes, the children's views are very important, and they can be brought out prior to court, and definitely they're brought out through a court process. I agree.
Thank you, Arthur. That was a great response. So definitely it's not just the parents' say and their views, but the children's views can be expressed through various channels, I guess, and the arrangements will need to factor those in. So Arthur's details again are here. So if you do have any queries, please feel free to reach out to him directly. Thank you, Arthur, for presenting today's seminar. It was definitely informative, and I learned a few things too around, especially the parenting responsibilities versus care arrangements. That's something I'll remember. So this brings us to a close for today's seminar. Just as a reminder, the seminar is being recorded and will be made available through our YouTube channel following the close of the session. And Arthur has provided a one-page handout which was shared with registered participants by email, so you'll have a copy of some notes that you can refer to in the future or share with family and friends. Please do follow us on our social media platforms. We rely on word of mouth to help share the work that we do, and hope that people that join in the future can make good decisions by being informed. Our next session is on Wednesday, the 29th of November. That'll be on workplace sexual harassment, so a very sort of topical issue at this point in time. It's received quite a lot of attention through the media as well. So if you have experienced that or know of someone that has experienced it, please do share that seminar details with them so they can join and learn a bit about what they can do. So that brings us to an end. Thank you again, Arthur, and hope those that have joined today have learned something. And for that, that'll be about it. Thanks, Arthur. All right, bye for now.
Thank you. Thanks very much.
Yeah.